Hail to legal warriors. In this video, I'm going to cover 3 different types of first court appearances. And this is important that you know this because if you have a court appearance, there's different types that you may be going to, and there's different things you need to know, things you need to worry about, things you need to be prepared for. So if you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now I'm just going to jump right into it. There's a whole bunch of different types of court hearings out there. There's family law cases, there's bankruptcy cases, but if you know anything about this channel, this is a criminal law channel. We cover criminal law and something that's close to criminal law, protection or restraining order hearings. And so if you have a court date, there's 3 different types of first court dates you need to worry about. 2 of them apply to criminal law and 1 applies to protection orders. So let's start with the criminal law first. So if you get arrested for a crime or your loved one has been arrested for a crime, the typical first time you're in court is actually called, believe it or not, a first appearance. Now, a first appearance is different than if you're formally charged with a crime. We're going to cover that next. But a first appearance covers a situation where the law enforcement officer who made an arrest does not have the legal authority to initiate the actual criminal charge against the suspect. And so that applies to all felonies throughout Washington State. Law enforcement can effectuate an arrest, but they cannot actually file the real criminal charge for it to go forward. They can only file an arrest-type notice, typically called a super form, and then we're going to talk about the first appearance here in a second. And the second type of situation is for non-felonies, where it is typically a county-based police officer. For the most part, if it's a county-based police officer, their jurisdiction is an entire county or broader. That would be a sheriff, is typically a county-based officer, or a Washington State Patrol person. That's going to be statewide. Those officers, for the most part, also are only allowed to make arrests. They are not allowed to file the actual criminal charge into court. So the court rules control what happens at court appearances. And in this situation, we're talking about a first appearance. The court will say that a first appearance, the defendant has a right for the court to review the paperwork and determine is there probable cause or reason to believe in writing from the law enforcement officer that the person arrested committed a crime. If there is no probable cause statement filed, or if the probable cause statement is insufficient to support the allegation of a crime, then the court is not authorized under the rules to set bail, to hold the defendant, or set conditions. That suspect must be released. Now, most of the time at this first appearance, the super form or the probable cause statement is going to be sufficient to state a crime. It's important. We have to know that we're not allowed to present our own facts as a suspect at a first appearance. We can argue what's in the report, whether or not, if it were true, it constitutes probable cause, but we can't swear to our own testimony. That's not what the hearing's about. This is not a guilt or innocence hearing. But this hearing is very important. At the first appearance hearing, the court is supposed to determine if there is probable cause, what conditions should be set on the suspect going forward. And the typical conditions would be lawful behavior, possibly no contact with certain people or certain classes of people like children or things like that. And then more importantly is bail. If the court determines that the alleged offense is a violent offense, now that's a term of art, things that don't sound violent can be violent, including DUI. If it's a violent offense, or if the suspect might interfere with the administration of justice, or if the suspect is not likely to reappear without posting bail, that is cash money or a bond, then the court is allowed to order the suspect held until that bond is posted. And sometimes it's a really big number. If it's a very serious felony case, you might see $250,000 needs to be posted before someone can get out of jail. So at that first appearance, it's going to be important to know there's typically going to be an attorney of the day, some type of public defender present who's pretty skilled at arguing bail. For some counties, we advise that if you're looking at our firm, that we go in and make an argument. In some counties, we sort of advise that we don't, and there's strategy reasons, which I'm not going to cover here for that. But it's important that anyone that's supporting the suspect, they have some way to participate in the hearing if possible, by Zoom or in person, to show the judge their support in the community. This person isn't likely to run off to Italy or somewhere else because their whole family is here. So at that first appearance, they don't take a plea of guilty or not guilty. Remember, there is no charge yet. They say, hey, is there probable cause? Prosecutor, what do you want for conditions? Defense, what do you think the conditions should be? The judge sets the conditions, and then they're typically going to tell you what a second appearance date is, when they need to come back, usually 1 or 2 days later. Or in some counties, they don't give you a new court date. They just say, hey, here's the date the prosecutor has to rush file, or a prosecutor recently called it deadline file, a case to maintain those conditions. And I've covered this in other videos, but basically the court rules say that if a person is subject to conditions from the court can only maintain conditions on an arrested but uncharged suspect for 3 court days. Now, there's some tricks of the trade that prosecutors use. If that 3rd court date comes up and they don't feel comfortable filing the actual charge, they can file something that I call a holding charge, sort of a fake charge, to buy another 14 days, and that's beyond the scope of this video. But talk to your local attorney, and hopefully, if they've been around for a while, they actually know how it works in that county. If they do not file that charge in the 3 court days, this is a huge practice pointer. It doesn't mean the case is dismissed. It doesn't mean the case is dropped. I'd like to pull out my hair every time I have someone on the phone say the case was dropped, because that's what it seems like, but it's not accurate. All it means is the prosecutor has up until the statute of limitations to decide what to do. And some counties have a culture of rush filing everything, and some counties rush file nothing. So talk to your attorney. Don't make the mistake of thinking because the case wasn't filed in 3 days that the case is over. It almost always is not. So that was a long time to talk about example 1, that is a first appearance. Example 2, which is probably a little more common. Typically, your first court appearance is what's called an arraignment. An arraignment means there's actually a filed criminal charge. Now, when do we immediately have a filed criminal charge? For your first court date, well, it could be you got pulled over by a local police officer, a city police officer, city of Linwood, city of Seattle, city of Mount Lake Terrace, city of wherever. And those officers, for the most part, can file their own non-felony charge right into court. And if you take a close look at the ticket, you may have a court date on there. Now, if you do have a court date on there, pay attention to that, because if you miss court, you could get a warrant for your arrest. Now, in some type of cases, that first court date's going to be the day after you were cited, more often than not. That's going to be for 2 types of charges, DUIs and domestic violence charges. DUIs, the court is instructed they have to set conditions to protect the public on the defendant, in this case because it's charged, like an interlock device, don't drink, stuff like that. And in domestic violence cases, they need to consider a no-contact order to protect the alleged victim. So if you are cited directly by the officer, look and see if there is a date on the citation. And if there's not, you're going to want to contact the court, or at least a local attorney or a well-known attorney, even if they're not local, the next day or that day to try to figure out what's likely to happen in that jurisdiction. What's the other way you might get that first court date for an arraignment is getting a notice in the mail. So in all these cases that don't get rush filed, or that you never get arrested and it just gets reported and it goes to the prosecutor to decide, well, they don't come knocking on your door if they decide to file a charge. The prosecutor fills out the criminal complaint or the information, depending on the type of case it is, and they file it into the court. Then when it files into the court generates a case number, and they send a summons to the defendant. That's why you got to be checking your mail. If you have a private attorney, someone like us, we might be checking the records for you to sort of backstop you in case you miss it, in case you're on vacation. But you'll get a summons saying, hey, come to court date for your arraignment. And that arraignment, it's the same type of things happen at the arraignment that happened at a first appearance, except they are going to take a plea of not guilty at that first court date, because now you're officially charged. So now the judge has to look and see, is there probable cause? And if there is, then they can set the same type of conditions that were set at what would otherwise, in some cases, be called a first appearance. In this case, though, once you enter your not guilty plea, they're going to give you future court dates, typically 2 or 3 more court dates, a trial date, a pretrial date, sometimes also something that might be called a confirmation date. And basically, you have to worry about the most close in time date coming up is the one you need to worry about, because that's typically going to be the date when you're next required to appear in court. Now, at that arraignment, they may be required to set certain conditions on you. If you've had a prior DUI and it's a new DUI that you've had, then they've got to set an interlock device at the minimum. They might have to put a scram bracelet on you, all types of different stuff they can do. So it's the same type of cautions. You want to be prepared for that hearing. If you can have an attorney, please do. If you can have people, if it's a scary case, you can have people come to court with you for support in the community. But more often than not, on a misdemeanor type non-felony case, the conditions will be fairly standard. Stay out of trouble, stay in contact with your attorney, don't have new crimes, stuff like that. So that's the second time, and there's a big difference. The first one, you're not officially charged. You just had a really bad day. You got arrested. The second one, you are officially charged, and now we really, really have to get moving on this case. So those are the two types of first appearances for criminal cases. For a protection order case, you'll usually find out that you have a time to appear for the first time in court when you're getting served with documents. So a protection order, or what people call restraining orders, are civil cases where one person is asking the court to limit the rights of another person. The person asking the court to limit the rights of the other person is called the petitioner. The person who's having their rights limited is called the respondent. And when I say rights limited, typically ordered to not have any contact with the petitioner, possibly thrown out of your own home if you live with the petitioner, possibly restricted from seeing your own kids. If you have kids with the petitioner, you might get thrown out of the school that they go to, or if you work in the same place. It's a pretty big nightmare. And how you find out about it is a knock on the door, typically from the police, and they're giving you this temporary protection order against you, and they're giving you a petition. They might give you a thing telling you to turn in your guns. They might take your guns. And if they're not knocking on your door, if there's no weapon surrender, they're allowed to email it to you as well. And so I need you in that case to take a close look at the temporary protection order that's been issued, or a denial order sometimes, where they didn't give a temporary order. In either case, there's going to be a court date for the first time you need to appear in court on this protection order case, and it's different. There's typically only going to be one court date for you to show up to, unless you ask for a continuance when you go to court to ask for more time to respond to this big old mess you got served with. And remember, protection orders are civil, and the court expects you to file a written response in response to what the petitioner wrote in his or her written petition. Now, if your response might expose you to admitting criminal liability, you definitely need to talk to an attorney, because oftentimes, these things involve crimes, allegations of crimes. Remember, though, it's not a criminal matter. This is not involving the police. This is one person versus another, but a violation of the order is a criminal matter. So for this time you're appearing in court for the first time, you definitely need to have consulted an attorney if you can, because you're not entitled as a respondent to any type of public attorney, to any type of public defender. It's not a crime, it's civil. So what's the big practice pointer? Look at the paperwork, see what court it is you're supposed to go to, see when you're supposed to be there, and see how you're supposed to be there. Sometimes you can do it by Zoom, sometimes you have to be there in person, but be reaching out to an attorney to help you with this. And typically two types of main attorneys handle these. Typically criminal attorneys and family law attorneys are the main type of practice areas that do this, although I think the criminal defense firm is a little more well equipped to jump to things quickly because of the very nature of our business, representing people that never expected to get charged with crimes. We're sort of designed to jump into things. As to other type of practice areas, maybe it's oftentimes less emergent and more happens over time. So those are the three different types of first court appearances you might have. It's important you know the difference. It's important you know the difference on the criminal side. It's so confusing, and it makes so many people suffer later. And on the civil side, it's important that you don't miss court dates and you don't screw up, because if you miss one, you don't get a warrant for your arrest. You get a default order. Now you're restrained, and you never got any say-so at all. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. And more importantly, if you got a criminal matter or a protection/restraining order in Washington State, feel free to give my office a call. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.